for those of you who are joining us, the whole big group, welcome. Thank you so much for joining us. I'm Christa Kemp. I'm the Director of Donor Relations for the Vermont Land Trust. You are signed up today for estate planning workshop for women. So as they say on an airplane, if that's not what you signed up for, you can exit left now. Otherwise, welcome. A few things I'd like to let you know about before we get started. I don't know how comfortable people are with Zoom if you've done this before, but I'll walk you through a few of the logistics to help in your participation of the webinar. So the first thing is, if you drop your cursor down to the bottom of your screen, you'll see a black panel. Your mute button is on the left and your video is beside that. This is a webinar, so the panels you'll see are just of the presenter and the moderator. You won't be seeing other individual participants on the screen. So sometimes Zoom meetings show everyone, but this one's a little bit different. So don't be surprised if you don't see your own face. We are going to encourage people to participate throughout the webinar, asking questions either verbally or through the Q&A box. If you look down a little more to the right, you'll see a participants box. If you click on that, it will give you an opportunity to digitally raise your hand. You can either do that, and Kate Shaw will call on you and we'll listen to your question, or you can click on the Q&A box and type in the question, and then we can answer it that way. And so it's a good time to let everyone know that this webinar will be recorded. So if you say your question out loud, your name and whatever image you have of yourself will appear on the screen and it will be recorded. If you'd rather stay anonymous, I would recommend typing in the Q&A box. Another alternative is there's a chat box. So we'd like to not put questions in the chat box because that gives us 3 different places to have to look for questions. If you have a resource to add or a comment or something like that, go ahead and share it in the chat box, but we'd love for questions to stay in the Q&A and verbally by raising your hand. Okay, I think that answers that, unless anyone has any questions about the logistics of participation. Anybody? All right, terrific. Well, as it goes, one of my favorite quotes is, "Where are we going and why are we in this handbasket?" It always makes me laugh when I see that, and it's now a bumper sticker. But along those same lines, you might be wondering, why are we here today doing this, and why is it only women? And so we, the Vermont Land Trust, about 4 years ago, started noticing a pattern in our bequests. We noticed that 8 out of every 10 were coming from women. And we also knew at the same time that over half of Americans did not have a will. So we were thinking, wow, that's a big correlation there. So we decided to run focus groups. We ran 3 focus groups for women around the state of Vermont, understanding that lots of people needed wills, needed to start estate plans, but hadn't done it. So we wondered what would lower the barrier, make women feel comfortable. How could we start that conversation? And what we learned is uniformly, women wanted free advice, a safe, supportive forum to ask questions, to learn, and get support about the decisions they had to make. So now, fast forwarding to 2020, we learned that women hold $72 trillion in wealth. That's about 32% of the global wealth in this world. And according to RBC Wealth Management, women are redefining wealth giving and legacy planning. And I'm thinking, damn right we are. We are a powerful force to reckon with, And what we found at the Vermont Land Trust specifically is that women care very deeply about their families, their friends, their communities, and the world they live in. And we're finding that women are having an enormous impact in doing the work that the Vermont Land Trust is doing right now. I'd like to pause for a second and talk about COVID-19. I want to express my sincere sympathy if anyone is being directly affected by this pandemic. I mean, in a way, we all are by sheltering in place, but for the people who are actually sick or have family members who have died, we're deeply saddened by that. We, the Land Trust, are trying to support people in direct response through farming, through helping with food systems, and by increasingly sharing the places outside that are open for people to get outside, to commune with nature, to have a spiritual connection, to get fresh air and exercise. And at this point now, we're able to experience those places in a socially distanced manner with our friends and family. So taking that a step forward, without further ado now to launch into our conversation, I'd like to introduce our panelists. We have three experts with us today. I'll first start with, I'd like to give them an opportunity to introduce themselves and to talk about their business. We have Jeanne Blackmore of Gravel and Shea. We have Susan Fowler of the Trust Company of Vermont, and Kathy Burns Kingsbury of KBK Wealth Connection. So Jeanne, why don't you kick us off and share a little about yourself and your business?
Hi, Christa. Thank you. Hi, everybody out there. I wish I could see you all. This is my second Zoom seminar, and it's really hard to talk to the little green light on your screen. Also, if anybody I know is in the audience, just send a little hello in the chat, because we just see your bubbles with your name on them. And I said hi to one person I know already who I owe something to. So I'm sorry. Now you've caught me, and I'll get you the thing. So I am an estate planning attorney, and I work at Gravel and Shea in Burlington, Vermont. We are all remote now. We've been in the cloud for about 2 months, and we're still working robustly on our estate planning practice. I have been a tax attorney and estate planner for over 24 years now, and have a small and large practice in that we accommodate large, high net worth clients and all the clients of our firm, whether they be new startups, individuals, just a wide range. We have a robust practice with 2 lawyers, a paralegal, a trust litigator, and an assistant. And I think that's pretty much the scoop for me.
Okay, thanks, Jeanne. And Susan.
I have to unmute myself.
There we go.
I am Susan Fowler. I work at the Trust Company of Vermont. Before coming here, I was in private practice, and I was the Chittenden County probate judge for 22 years, and came to Trust Company of Vermont in 2016. We are an employee-owned investment management trust administration company with 5 offices in Vermont and about 40 employees. And here we work with folks to manage their money, and also we work pretty closely with Jeanne's office and numbers of other law offices around the state, helping people with drafting of their documents and administration of their trusts. That's it.
Good. Thanks, Susan. All right, Kathleen.
Well, first of all, thank you for including me this time. I know I'm new to the panel. My company is KBK Wealth Connection, and what I do is I coach, speak, educate, and consult on the issues around financial psychology. So in other words, helping people and professionals, individuals, couples, and families talk openly and honestly about money and the emotions connected to money. So certainly that fits with estate planning. I live here in Waitsville, Vermont, so I'm a Vermonter, but often my work before COVID-19 takes me throughout the United States and Canada. But I do a lot of virtual trainings, and it never becomes more comfortable, Jeanne, to stare at that green light. But I'm really excited to join all of you today.
Terrific. Thank you so much, all three of you, for joining us today. I think we have a robust group. I'm pleased that via webinar, we're able to expand and have a larger group than we normally do. So I'm very excited about that, and I want to welcome everyone. I'll kick off the conversation first by sharing the results from the short survey I sent to people in the follow-up. My first question was asking people how they're feeling right now. And the response was that 36% of people feel content, 31% feel anxious, another 31% feel hopeful, and 5% feel resigned. I think that's a good cross-section of what I see in my community, in my family. So that's interesting. What's helping people stay balanced? 75% of you find time outside is keeping you balanced.
Yay.
Yeah, exactly. Let's use that, our natural resources. 50% of you find talking with your friends and family a balancing point. 20% of you are baking. And not surprisingly, watching the news is not keeping anyone balanced. I wish I had a laugh track in here, because I feel like I'm cracking jokes and nobody's laughing at me. So I know I'm feeling a little like a stand-up comedian who is bombing.
I'll laugh at you.
Okay. Okay, you all have. And then lastly, the question was, has the pandemic influenced your estate planning? 35% of you said it has prompted you to start. 50% said it's prompting you to update your plans. And 20% of you said it had no effect on what your planning is. So that's interesting. And it's going to launch us now into our first question of, when should I begin thinking about my plan? Is there a particular age or an event that would start that? Jeanne, why don't you kick us off?
So my general answer to that question, and I want to encourage people to use the chat function or whatever function Christa said to ask questions, because this panel has always had a lot of give and take to it, and I think it'll be more productive that way, because the green light is not that communicative. The best time to start thinking about your estate planning is the time that you have stuff, any stuff at all, that you care what happens to it when you pass away. So that can be when you're very young, if you have family or a sister or a brother or parents in a bank account. Also, estate planning doesn't deal just with things you dispose of on your death. It deals with end-of-life care issues. So not only do you want to have documents in place to attend to your assets after you pass away, but you also want to have a healthcare directive and a power of attorney so that somebody can care for you when you're at the end of your life or indisposed because you've had a surgery or whatever the case may be. So that is sort of the basic answer. When you do an estate plan, you have to keep in mind that it covers the present situation. You have to keep your eyes on it all the time, because as things change, you'll need to update it. And that is why so many people are revisiting their estate plans right now, because circumstances have changed.
Yeah, I think it might be interesting to find out how many people on the webinar today currently have a will. So I'm going to launch that poll, and for all our participants, if you would answer that poll. We've got, we're almost to 100%. Wow. All right, 100% have answered. 66% have said yes, they have a will. 34% said no. So it's along the same lines as the national average. All right. So knowing that, what might be the first step that someone would take regarding getting their plans going? Jeanne, do you want to?
Sure. I'll take a stab at that. I like this because I can keep Sue Fowler quiet. So the first step to making an estate plan is always looking at your stuff, making an inventory of what you have. And that is often a step that's really scary for people. And I know Christa has circulated our questionnaire in advance, but sometimes, and I hope this is improving, women in particular have had a hard time emotionally just sitting down and saying, here's a list of my stuff and what it's worth and the form that it's in. So for example, I have a house with a mortgage and a 401k with this balance and a checking account with this balance and an investment account with this balance. And I own 15% of SAP or whatever the case may be. But you have to know what you have in order to figure out how you're going to deal with it. And that's a good, Kathleen may want to touch on this point also, but understanding what your finances are and your assets are is important for a lot of reasons, including figuring out how to do your estate plan.
Mm-hmm.
Well, I just want to jump in real quick, Jeanne. I think when you talk about, that can be hard to put down on paper, I think that really feeds into what your relationship with money is like and your wealth or maybe the lack of wealth, whatever the case may be. And I think that you can do it in small bits if it becomes overwhelming, and or you can work with someone like a coach or a financial advisor or even a friend who's a little bit more financially literate than you, or just can, help you get through that experience. So you don't have to do it alone if it becomes overwhelming, and you can do it in small bits.
That's really good advice. I think, there's another interesting question that I'm going to pop up right now about having conversations with family or key people about your plan. Would people just fill that in? And that can often be a tricky place to start or to even think about. But if the conversations go positively, I could see it as a spur to make completing the estate plan easier. Whereas if it were, you anticipated a contentious conversation, it would make you not want to go there. So let's see how people have done so far on their own. It's looking about a little more, 56% have had the conversation, 44% have not. So Kathleen, how can you encourage people, or what might you offer for people to get over the fear or the dread or the, just unknowing of getting this started? How do you do that?
Yes, I get asked that a lot. And, one of the things that if we were live, I would love to know, for the people who have had the conversation, how many of them had conversations that actually were not what they anticipated. So part of what people need to be thinking about is when you have a feeling, which is very normal to have a feeling about doing some estate planning and to be able to think about your mortality, think about all your stuff, think about money, which is one of the most taboo topics in our society, and have feelings about that. So whatever feelings you're having, I think the first thing, Jeanne and everybody who's listening in, sorry, Jeanne became the MC right there. Christa and everybody who's listening in, anybody who's having feelings about it, really normalize that. There is nothing wrong with whatever you're feeling, and don't judge it. Like, for instance, don't call yourself lazy or somehow, beat up on somebody in your family that doesn't want to participate. In terms of starting the conversation, I think the first place to start the conversation is to really look at what is important to me. That if we self-reflect, that if we get education like everybody's doing on the line, if we really think about what's important to us, what our feelings are about this, and this isn't only just about stuff. Stuff is really important, but it's also about passing on family values and lessons and thinking about things that maybe have less or no financial numbers attached to them, but are very, very important to pass down. So I would start with self-reflection, and then I would approach somebody, if you have a partner, approach your partner and ask curious questions. So the tricky part with a money conversation, and especially a money conversation that is emotional or potentially could get emotional or contentious, is we often go in thinking I have to convince the other person what to do, what my opinion is, and I have to be heard. And it's really important to go in completely opposite, being open to hearing what their perspective is, asking curious questions, and then at some point sharing your viewpoint. So, remember, whatever you're anticipating in your head, what my experience has been both in my personal life as well as in my professional life, helping people through these conversations, is that what's in here isn't always what ends up happening. And no matter what ends up happening, it often is a much better outcome that can be worked through while everybody's alive, as opposed to leaving somebody feeling angry and anxious and fearful and whatever they might be feeling because they can't have that conversation with you after you're gone. So hopefully that answered your question, but certainly people can follow up and ask additional questions.
Christa, I just want to jump in. Marilyn typed in that she's talked with her son, but not with her stepchildren. And that brings up for me about different family dynamics and what the implications of that are.
That's a great question. I mean, I'll jump in and then I'd love to hear from Susan and Jeanne as well. I think when you have a blended family, often it's more complicated. And so it's more complicated in terms of just the decisions you might make, in terms of how you're passing down things, who you're passing down things to. There is some research that whether we like it or not, sometimes parents do have a different feeling about passing down wealth to their biological children as opposed to their stepchildren. And this is a time where pulling in an expert like Jeanne or Susan or someone who does coaching like me to help you talk through those dynamics before you have the conversation, and or have you think about what's important to you and how do you want to communicate with all of your children. And so it's hard to give a set answer, but I'm really curious what the other panelists have to think about this one, because I'm sure you see it all the time.
Yeah, Sue, do you want to jump in on this? Because I know you've had a lot of experience.
Yeah, I'm always the one with the bad stories, because from being if you do things well and you use somebody like Jeanne and you get things moved smoothly through, you don't go to court and everything works out just the way you wanted it to. If you don't do those things and you don't speak with your family and you set things up, or you fail to set things up entirely, which would jump forward to what if I don't have a will, then you end up in court. And oftentimes what happens is those blended families really explode in the courtroom because dad's second wife is younger than his oldest child. And it makes for some hard feelings. So one of the main reasons to think about these things ahead of time is so that when you're gone, it doesn't leave those surviving you in a position of having to go to court and duke things out.
A continuing comment is, it with a blended family like that, if the majority of the estate is going to the biological child, how would you explain that to your stepchildren?
We might want to talk to the shrink about that.
Well, I guess I would start by the partners having a conversation about why those decisions were made, what were the rationale for those decisions, then asking the children, and depending on the family dynamic, you may do this individually, you may ultimately do this as a group. That would be on a per family basis, but start to look at what are they expecting. Is this a surprise to them? Is this something that's to be expected? Is this something that's going to be upsetting to them? And then the ultimate goal is for the people who are passing on their wealth or doing their estate planning is to be able to communicate why they're doing what they're doing. Because often when you can have that dialogue, even though that's not the most comfortable thing to be able to doing, when you have that dialogue, there is a back and forth that can happen. Again, if it ends up being that it feels like it just blows up and it goes nowhere, that's when you bring somebody in to help you with it. But that ultimately what I have found is through a series of conversations, people gain some clarity. And ultimately, because money is so emotional and estates and passing down, it often is less about the dollars and more about what those dollars symbolize. or what that piece of property symbolizes. And so it's really getting to the underneath of what does it mean? Why is that happening? And how do I try to explain this? And if they're adult children, I mean, they may have emotional reactions. We're all human. Those reactions may be very different than what you anticipate. They may be right on target. And then it's having a series of conversations about why that is. And, you know, ultimately, I think it's up to the person who's passing down the wealth to decide how they want to do it. But it's better to not do that silently, because then people make up all sorts of stories that often are much worse than what actually the intention was. I find most parents are trying to do something in a loving way, not necessarily a punitive way, even if that's what it feels like on the surface. So hopefully that helps with that particular situation.
Yeah, that's really helpful. Thank you all very much around that category. Let's shift now a little bit toward more of the logistical things. So talking about documents, Sue, Jeanne, do you want to lead us off with what are the physical documents that we need?
I can take a first stab at that, and then Sue can complain about my documents. So I think I mentioned in the beginning, you have two categories of documents in your estate plan: the ones that help you when you're at the end of your life, and then the ones that deal with your stuff once you're gone. So for end-of-life care documents, you will need a general power of attorney, which you use to designate an agent to advocate for your day-to-day personal affairs, like canceling a credit card if you get dementia and go shopping too many places, going to Social Security for you, dealing with your IRA, and you need to have a healthcare directive where you designate an agent to advocate for your healthcare wishes. And those are pretty standard documents, pretty easy to put in place. For your documents that you have to dispose of your assets on your death, at the simplest, you would need a will, which is a formal document overseen by the probate court where an executor disposes of your assets according to the instructions you leave, to a more complex structure where you use a trust to dispose of your assets. And that's a slightly more complex document that is designed to dispose of your assets without having to go through probate. So I don't want to get in too much depth about that right now, but for things after you're gone, a will, maybe a will and a trust, and for end-of-life care, a power of attorney and a healthcare directive.
Sue, any complaints?
No, none. No. As usual, she was impeccable.
Okay. All right, Sue, you're on the hot spot. So how do I know if I need a trust? When is a plain old will not enough?
Well, Jeanne could probably give a more detailed answer to that, but I know when I started at the trust company, having come from the probate court, I just assumed everybody went to court, and that was a good thing to do and a nice place to be. Then I learned that nobody wants to go to court, and the whole idea of trust planning is to avoid never going to court. So it kind of like shrunk me down to peanut size. And so when you have a trust, what it happens is the plan that you put in place just carries on when you die if it's done correctly. So there is no reason to go to court and have to have your will go through that process and appoint an executor and jump through the hoops that are naturally associated with the administration of an estate through the court process. So if you don't care, if you don't have any relatives and you don't really care how much hassle it is for somebody to go through the court system, then you probably don't need it. But if you want to make it easy for the people that survive you, oftentimes a trust is recommended simply because you put it in place, you die, and the trust just keeps going as if you were still alive. That's a nutshell. Jeanne might want to add to that.
I'm going to add a little bit because I see that somebody asked a question about why you would have a will and a trust. So a little more in depth. So normally when you die, if you own an asset directly in your name, in order to get that asset to the intended recipient, there's a couple of paths you can take. The asset can have a beneficiary designation, like a life insurance policy. And in that case, the asset passes automatically by operation of law. if the asset doesn't have a beneficiary designation, like a house or an investment account at Merrill Lynch, the only way for that asset to get to where it needs to go is for a judge to say, I decree that that asset can go from this person to that person. And that's the probate administration process. A way to avoid that is to use a trust to do the disposition of your assets. And while you're alive, a trust is revocable, and it's an agreement between you as the person who made the trust and you as the trustee of the trust while you're alive. When you die, the trust becomes irrevocable, and at that point it acts like a will, and the person who succeeds you is bound by its terms. And because the successor trustee owns the assets in the trust because you put them there while you were alive, there's no need to get the court involved. So a trust is like a private will. It has the same language as a will, but it's not in a public forum. The probate court doesn't get to look at it. Somebody asked why you would have a will and a trust. We always have a will with a trust in case you forget to put an asset in your trust while you're alive. And then the will designates your trust as the sole beneficiary of the will. So for example, if you put your investment account, your house, your business interest in your trust, but you forget your people's bank account, that would be subject to probate.
And just look to follow up one thing on that. So when you're doing that, when Jeanne's talking about forgetting to put something in your trust, getting it in your trust means having it owned by the trust. So that's going to mean changing the title on your account so that it says it's owned by the trust, not you individually. And so oftentimes people will have a trust and then they'll go buy some new thing and they just buy it in their own name and they forget to buy it in the name of the trust. And that will end you up in the court opening an estate. It won't be a big estate because most of your stuff is in your trust, but anything you forgot to title in the trust is going to go through the probate court. So that's a consideration in whether you do a trust or not. Do you mind going through that exercise of retitling things in the name of your trust? We do that at Trust Company Vermont. We do that for people. Lots of people can do it on their own, but for some people it's a sort of overwhelming task.
The other thing I want to say is, and I think it's a great opportunity to review your estate plan every couple of years, or if it's complex, every year. And that's another opportunity, right? Where you could say, oh, I forgot to put this in trust. And so that review process is not only good for documents, it's also another opportunity to touch upon and kind of continue that estate planning conversation that you've started.
So we have two additional questions. Thank you for that, Kathleen. Two additional questions. So to put property into a trust, you'd have to change the name on the deed. Is that correct? So you'd be renaming it as the trust, with the trust as the owner.
You would. So for example, your deed right now might say that you own it just says your name. And when you redo the deed, it says you'll own it as trustee of your trust. So say for my house, it says that my house is owned by Jeanne Blackmore, trustee of the Jeanne Blackmore Trust. You have to get a real estate attorney to do all real estate transactions in Vermont, but that's a very simple procedure to do that. And we have found that when we send our real estate lawyers, trotting off to look at deeds, there's often mistakes or issues with people's deeds. And so it's a nice time to clean up, as Kathleen mentioned, clean up little things that are messed up here or there. I always liken this process to planning for a vacation, and you can leave the suitcase with like clothes and bathing suits all over the place and have your kids pack it for you, or you can organize it really nicely and zip the bag up.
One of the questions I got ahead of time was that a person didn't have the deed to their home. Is that a problem?
Everybody actually has
Town clerk's office.
All deeds are recorded in the town clerk's office, and the originals are with the town clerk.
Okay.
Definitely have your deed, all of you.
And then another question is, are trusts ever made non-revocable while you are alive?
Yes, Jeanne can give a good answer to that.
Why would you do that?
Okay, so we're talking about the basics of estate planning right now. We're just talking about people who don't have a bajillion dollars, taxable estates, kids with special needs and Medicaid issues. We're talking about the basics. You have stuff and you need to get it to the people you love. There are so many add-on things to layer complexity to estate planning. You may make an irrevocable trust while you're alive for estate tax purposes, to make gifts, to reduce your estate tax, to make gifts to children, to get them used to the management of money in conjunction with a real wealth manager. You may make gifts to a trust because you have somebody who may need Medicaid services, and so you want to put that in an irrevocable trust for various technical reasons. And anybody on this panel is happy to talk to people about that. There are charitable trusts that you can use. There's just a world of them. And if you have questions about that, you should pick one of the four and send them an email afterwards.
Another interesting question we received. So the successor trustees will own the assets in the same way you as the original trustee did, question mark. Are there any potential problems to this?
Yes. There are. You want to be certain that you're not necessarily naming your best friend or the person you feel like you really should name them because they're it's your mother or your sister. Because that trustee has a lot of authority, you want to make sure that in your trust you have maybe a trust protector who's a person who can make sure that the terms of the trust are being followed and also has the authority to remove the trustee if the trustee isn't doing a good job. And you often don't want to have a family member as your trustee. And it's sometimes wise, at the risk of sounding self-serving for my job now, it's sometimes wise to have a corporate or independent entity serve as the trustee. Oftentimes in court, I would say every time in court almost every time that we had someone trying to remove a trustee, it was often because someone had appointed a family member and then complaints about self-dealing after the original donor died pop up among the beneficiaries. You know, you're giving more to yourself, etc. So those are things to just think about. You really want to think hard about who you're naming as your trustee and your successor trustees.
I want to tag on one point to that just to make sure people aren't confused. If you have a trust as a will substitute, when you die, the trust becomes irrevocable and the trustee is bound by its terms. So they don't own the stuff in quite the same way you do. They have to follow strict instructions, which generally say, pay my final bills and expenses on this earth, divide everything into the number of kids that I have, and then cut them a check and give it to them. So they can't just do whatever they want. And there is a body of law in place to protect the beneficiaries. Hopefully it wouldn't become necessary to do that, but people can't just do what they want. They have to follow the rules that you make for them.
And to follow up with what Jeanne said very, very quickly, is one of the reasons that people run into problems is because those rules aren't readily known to average lay people. So when you appoint your brother as the trustee, he may be attempting to act in a fiduciary capacity, but not really understanding that he can't commingle his assets with your assets, or he can't favor one child over another, depending on whatever the terms of the document says. It has to be followed.
Well, and that's one of the things that comes up, I think, when you're picking someone and when you are asking someone, that this is not only an honor, but it comes with great responsibility. And so engaging those, the people that you are considering in a conversation, often if you have a couple people that you're considering and you have a conversation about it, once you get past the, oh, that's really nice you think of me this way, and you get into what that responsibility might be, some people self-select out. Or say, I've had that happen, or say, let's really look at maybe having someone professional, or having, I know it gets complicated when it's two people, but I think it's another opportunity to talk about what that means and to get beyond the niceties of, oh, you think so kindly of me, I get to be your trustee, as opposed to anybody who's done that job knows well, you think kindly of me, but boy, that's a lot of work.
Yeah, right.
So you have to have a certain level of financial knowledge or an ability to consult with lawyers and estate planners and kind of understand it. So I wouldn't rule anybody out before the conversation, but I would, and I practice this personally. I encourage people to practice this, is when you name someone, have a conversation with them and really keep that open dialogue, because that will, I think, also be helpful. Given a lot of the people that I work with that maybe aren't the ultra high net worth, a lot of times those conversations can be really helpful, and then also encouraging them to have a consultation with an attorney as well, to not be shy to get support if they end up in that role.
Mm-hmm. So do you have any real life examples where things have gone wrong, or how to guide people toward choosing the right people?
Well, this is a short seminar. I mean, there really are. There's a lot of funny stories about things going wrong, but to keep it on track so you can get to what you want to get through, it really is. If you trust your attorney can usually guide you towards someone who might be a good trustee, and or someone or a company that could do it. You want to make sure that you talk with them, even if you choose a company that or a bank, that you're talking with them, because you don't want a situation where you don't end up with any kind of continuity, and every time you're getting a different person every time you speak to them. But yeah, I think I probably should spare since we have more panelists now and we're answering longer, I'm going to try to nip my war stories.
Okay. So
Should I go? There's a lot of questions I think I can answer quickly. Should we just go through?
I think we're doing fine for time. It's 10:42. We have 45 minutes.
Oh, okay. I mean, there's 9 questions I think we can answer and move on from this topic.
Okay. Should we start with the next one with Kathleen about approaching the estate planning conversation?
Can you read the question to me?
How do I approach the estate plan conversation with my family?
Oh, the family again.
What if it's going to be contentious? Could this be an educational opportunity or a chance to share values? You've covered some of that already, but I think this would be a good time to sort of comprehensively cover it.
I think when I think about it, I'm going to reiterate some stuff. One is to get clear on what's important to you, and to think about not only the dollars and cents and the technical aspects, but also what are your values you want to pass down? What are things that are important to you? And I'll give you an example from my own life. When I think about, I don't have any kids, but I have nieces. I have a niece and nephews. And so when I think what's important to me and what conversations I want to have with them and what I would want, ideally what I'd want them to use any inheritance for would be, education's really important to me. Nature's really important to me. And so having conversations around that and focus on those values can be a really nice place to start, because it tends to be less contentious if you talk about what you love. And I also think I included in the documents a questionnaire, a family legacy questionnaire, which takes you through a couple of different areas. So you can use this questionnaire to get clarity for yourself. You can pass out copies. You have my permission to use it however you see fit, but pass out copies to your family members and have them complete it. And it talks not only about what are your values, but what are your financial successes? I mean, I think one of the things when we have a estate planning conversation, we often focus on what could go wrong. It's going to be contentious, as opposed to what's gone right in your life and what did you learn from that? Or if there was a financial mistake, which, oh, by the way, we've all made them, what did you learn that you'd want to pass down to the next generation? To really look at philanthropy. I mean, I know Vermont Land Trust is a great place to be thinking about for philanthropy, but other things of how can we have a conversation, and maybe while we're alive as a family, work together to think about where we want to have an impact. And by having an impact, we identify our values, we learn a little bit about finance, we're actually engaged in financial conversations that aren't that scary, because we're really doing some good work. And if there's a business, there's another series of conversations that you need to be having. So I think it's getting clear for yourself. It's understanding where people are coming from. And it could be as simple as, hey, I attended a workshop on Zoom the other day from the Vermont Land Trust. We were talking about women in estate planning. What are your thoughts about estate planning? And just open it up. So it's gathering some information for yourself, self-reflecting, and then being really curious. I think the hard part is when we think about estate planning and we think about the technical side, which is so important, that it tends to be more black and white, or there tends to be documents and things you can check off. With conversations, it's more of a journey of sharing what your thoughts are, what you're thinking. And ultimately, the more you have these types of money conversations, they get easier. It's like building up a muscle. It's like going to the gym. And so ultimately, I think you can start by simply asking some of the questions that are on the questionnaire, or just a big wondering of, hey, I attended this. What do you think? Often people want to talk about money. I know it's taboo, but the minute you show them that you're open to the conversation and you are not going to judge them for what they're saying, which is a little bit trickier with a family member than maybe a friend or a professional, what I find is often we find out some really cool information. Later, if we have time, I certainly can share a story about that. But I think that is kind of the general steps that I would take and the structure that I might use.
That's terrific. Thank you very much for that. So now we've talked pretty thoroughly about having a conversation with our family, who might be the best person to choose for the executor of your will or a trustee. Now we get down into sort of the nitty-gritty of things. Jeanne, what do they need to know? Location of documents, passwords, the name of attorney. What's the best ways to pass that information off to the people we're sharing it with? And what are all those details?
So as part of the estate planning process, so the first thing you do is you sit down with your attorney with all your financial data, and that seems like a big tangled mess. I don't know if anyone's been watching that comedian on Twitter who's been doing the voiceover of Trump speeches, and in one of her videos she had this big tangle of wires. That's how people feel when they come in to see me. And then we untangle all the wires and a pattern emerges, and by the end of the meeting we come up with a plan for how they're going to put all these documents in place. And we track the documents and we collect them in one estate planning binder that show what the plan is and where everything's going, and that it's all tucked away. And then people do a variety of things when they're informing family members of their documents and where they are. Some people make sure that everyone who's involved has copies of everything. Some people make sure that their trusted advisors have them, or their successor trustee only. So it really depends on the culture of that family as to how they share and organize what they have. And the same thing applies in terms of passwords and account ID numbers and all that kind of stuff. Some people are super organized and have everything, on a big spreadsheet, or they have some fancy system where there's some fancy piece of equipment that spits out passwords every 5 seconds, and the retina scan, and everyone in their family is involved with that. So there's no right answer to it. It varies from person to person. I can say that over the normal course of one's lifetime, things simplify. So by the end, as you're getting closer to the end, usually things are not as complicated as they were, and everything works out just fine, and you're organized, and your family member or friends are there for you. That's what happens 99% of the time, no matter how nervous some of the people may feel here or isolated right now. Most of the time, everything becomes very clear and organized, and the people who need the information have it.
There are a couple of questions regarding will versus trust. One is, all our assets are in both my name and my husband's name, and our IRAs list each other as primary beneficiaries. Is there a reason for a trust versus a will, and would the trust be in both our names?
So the reason for a trust versus a will in that case is to avoid probate. So when you whoever asked that question notes correctly that the way that estate plan is now structured, everything will pass automatically to the surviving spouse on the first death. So if the husband dies first, then all the bank accounts and the property and everything will roll over to the surviving spouse, to the wife or partner. But then what happens when that person dies? There's nothing to make it get where it needs to go. So when you're doing an estate plan for a couple, you have to consider the first death and the second death. You can take care of that upfront, or you can wait until the first person in the couple dies. But I don't like to do that because oftentimes, and Sue sees this a lot, when one spouse dies, the other spouse is bereft and doesn't feel like doing anything, and sometimes never feels like doing anything. And so it's good to have all parts of your plan in place today.
Okay. The next question is regarding property transfer. And it's going to be a two-part one because I got a previous question along these lines. In terms of property transfer, wouldn't it be easier to add my name as the co-owner on the deed of the property, or add my name to her bank accounts? And then the second part is, someone asked about giving property, a camp to 4 siblings, and what you might recommend around those things.
I'm going to answer this first, and then Sue can answer it second because of the
There's already laughter happening.
So sometimes people will try and sort of shortcut this process that I'm describing as a very formal process with a will and a trust by making everything spring where it needs to go when you die. And that can work sometimes. It can also cause tremendous battles. So if, for example, one parent will often put a bank account jointly with one of their kids who pays all their bills, and then there's a trust that gives everything to all the kids equally. Well, what happens when that parent dies and there's $1 million in that joint account and it all goes to that one kid and there's only $50 left in the trust that gets split amongst everybody else? That is a problem. And maybe the family gets along and all the kids share everything, but maybe they don't. So what I always tell my clients is you can control the form of your transactions, and you should do it. You shouldn't count on sort of Jimmy rigged things, a la Vermont style, to get things where they need to go. You should be very precise and control the forms of your transactions in the most precise way possible. Regarding the camp, that's a huge issue, and we don't easily resolve this issue. And Sue can tell you just nightmare stories of dividing up personal property and share homes, summer camps, just a nightmare. The most common way to give a camp to the next generation or to whoever you're going to pass it to is to put it into an LLC and pass the LLC interest to the family members and have an operating agreement that sets forth the game plan for how people are going to use that property. And then when they inherit it, they can change the game plan, but they all have to agree on it. But that's the best you can do. And then Sue, I'm sure you have many things to add.
No, that was really good. But I will give you the description you had of and it happened so often. As you have 5 kids, one of them's really taking care of mom. So as mom gets older, she puts her bank account in both names, her and the beloved child who's taking care of her, with the understanding that that child will divide all that money up when mom dies. But that isn't legally what happens. It legally becomes the money of that one daughter. And I had countless hearings, I would say, where mom dies, the estate gets filed, there's nothing in it, and another child comes in and says, well, where's all the money? There was, $500,000 in this bank account. Well, it now belongs to that one child, and she doesn't want to share, and it's legally hers. So I think what Jeanne says in terms of don't rely on necessarily perfect goodwill among all the kids when you're gone. You hope that it happens, but it's better to be cautious and set things up the way you really want them to go beforehand. When in my own family, my dad did this exact thing, and with one of my brothers, put him in charge of, gave him joint ownership of his account, which is fine. He's a totally trustworthy brother. But I spoke to my brother the other day and said, I think you should take some money out of that account and put it into dad's investment account, which is meager to begin with. And he says, I don't have any of that. Did you see my new Tesla? So that ended that conversation, but that's how that works.
Yeah. Well, there's another consideration beyond children and family members. It's pets. And someone has a question about particularly long-lived pets like parrots, and wondering if those are considered property within your assets, or is it something you want to set up a trust for the long-term care of the pet? How have you seen these things addressed?
You can put in your trust or your will that you want someone to take care of your pet, and you can set aside a certain amount of money for them to do that.
Okay, perfect.
I have to just refer people to, I have a podcast called Breaking Money Silence, and I did an episode on breaking money silence around pets and estates, which is kind of fun. So if people want to check that out, it's just at breakingmoneysilence.com. It doesn't talk about the legal aspects, as you can imagine, that's not my role, but it does talk about kind of emotionally what you want to do. And being a pet mom, I think that's a really important thing to consider.
I'm really glad this question came up. It hasn't come up in any of our previous workshops, and I think it's a really important one. We spent about 15 minutes talking about puppies just before we launched this webinar. So clearly we're all into the animals.
I have two additions to animals that are important. The first is that even though it doesn't feel like it to us, animals are just our personal property. And so they are actually transferred to a trust with a bill of sale. And that's one classic probate avoidance document. It's just a paragraph long document, and it says all my stuff. And then there's a non-exclusive list of what stuff goes to my trust, and pets can be included. And if somebody has horses or parrots or other things, I encourage clients to have very detailed instructions for those really complex animals, because if you don't, it can be really, and Sue can talk to this, she's a horse person, and so is Kathleen, it can be really, really challenging with a horse. If you have a trustee or an executor trying to care for your horses and place them and feed for them and care for them, and we have had very difficult situations in that regard, especially horses.
Interesting.
I did have one case that was in all the time I was at the court was the most, I got hundreds and hundreds of letters. Someone put in their will that they wanted all of their animals killed when they died.
Oh my God.
And I said, I ruled against that, saying that they could not do that. But I literally received letters from all around the country on both sides of it, equal numbers. People saying they're just chattel, and if he wants to kill him, he has to kill him, and you have no right to not let him kill him. And some people, I gave them to a rescue place, and they had to, the person that I gave them to had to file something every year. And people actually came to the court for years to check to make sure that the people that the horses were entrusted with filed those reports. And they were not people that were supportive of saving the animals. They were people that thought the animals should have been killed. And they were sure that by giving them to this rescue, it would prove the point that they should have been killed. It would have been more humane. It didn't turn out that way. They were fine. But it just goes to show how intensely people feel about it. And what you think seems logical isn't by any means what you can expect most people to think. So be detailed in what you want to happen.
I think the next question that came up is one that probably many people are facing, because we are seeing an increased interest in getting plans done during this pandemic. A woman, a participant, her mom lives in Maine and she lives here in Vermont. And she's wondering if there's ways to draw documents up virtually, how they would get those things completed when there's such a distance between the two of them. And with people sheltering in place and the change of pace of work right now.
This is a super interesting question. So for most states now, and Vermont acted pretty quickly in this regard, have enacted emergency statutes and provisions to do witnessing of documents remotely, like by video. And so that can be done in Vermont. And all of my estate planning meetings are on Zoom now. So it can be done. It takes much longer. Doing all business now is like swimming with cement shoes on, basically. I mean, it gets done, but it's just very slow. I know that most estate planning attorneys, despite the ability to do things remotely this way and even to witness documents remotely, prefer to basically like do business in fields and parking lots and front porches and looking through windows because it's easier, and the documents are very formal and have really strict signing requirements. And so it's easier to do it live. Trust Company of Vermont has gone to at least 2 houses for me and signed documents on the front porch, looking through windows.
Yeah.
So it can be done. You just have to contact the lawyer in the state where the person who's doing the estate plan is. So in Vermont, you'd have to make sure that however documents are signed meets Vermont requirements. And if the person is in Maine who's doing it, then you'd have to work with their lawyer there.
Okay. Another interesting question that's come up, a participant said, I'm not a U.S. citizen, although a legal resident, but I own equity in the U.S. Is it enough if I have only one beneficiary, a child? Is there any, is in the U.S., will it be enough if I have, or wait, equity in the U.S.? Oh, is a will enough if I only have one beneficiary, or is there anything else that I would need to consider to secure her inheritance?
That can be a super complicated question,
Yeah.
but I'll give a very simple answer. So a lot of it depends on whether you're a U.S. resident, green card holder or not. And there may be serious estate tax issues here, but the general rule is that if you have tangible property in the United States, you need a U.S. document to pass that asset along. And that can be a will or a trust. If it's a will, then you will have to go, or your daughter would have to go through probate. And that is something I would not want to do, because that's a flag to all taxing authorities that you are passing an asset as a non-U.S. citizen. So I would use a trust, but because doing estate plans for non-citizens is very complicated, you should definitely consult a lawyer about that.
Okay, this leads to a really good question. How does one choose an attorney? There are so many names and so many different ways.
So I want to pipe in there for 1 second. So there are, from the court's perspective, very skilled estate planning, like in anything else in the world. There's really good people who are great at what they do and people who are not. And there are some of the people who are not are very good salespeople. And good lawyers, as any of you have ever dealt with one know, can really help your life, and bad ones can cost a lot of money and not help you at all. I mean, I'm just going to say Jeanne Blackmore is probably one of the best in the state. And she can probably refer you to people. We can refer you to people. Kathleen can probably refer you to people. You can also call the probate courts in the county where you live, and they are not allowed ethically to give you one person's name, but they can give you a short list. And so if you called the court and said, I'm looking for a probate attorney in my neighborhood, can you tell me? And by probate, we just mean estate planning. Doesn't mean necessarily you're going to end up in probate court, but somebody who knows the estate world. And they can and would likely give you a list of 3 or 4 or 5 lawyers that are competent and good in your area. I wouldn't just pick one out of the phone book. I really wouldn't.
Can you give us a few red flags? If someone has called an attorney, what are some parts of the conversation that might send up a red flag, or
For us, it's a person, an attorney wanting to put themselves in as the trustee and the successor trustee, and that's not necessarily wrong, but it's a little bit of a red flag. Another is a person charging an astronomical upfront fee, or we've actually had an attorney that was charging people a fee like $6,000 to be your lawyer in the future if you ever need one. I mean, these are not ethical things.
I would say, I just would say, you know, personality wise, you know, when I was looking for an estate attorney, and full disclosure, Jeanne is mine. I did my due diligence, and I would encourage anybody to do this. And the beauty of women is we're really great at sharing good experiences and not good experiences. So I would say get a short list, whether it's from your friends and or the courts. You know, often the same names keep popping up. And then interview them, you know, briefly about their philosophy, how they work. I mean, I know it takes a little bit of time, but this is like your life and passing your life on. So it's worth that investment of time. I think women in general also have a good gut sense. If somebody's really pushy, is really all about getting you to sign, as opposed to, you know, there's a process to this. I think that's another red flag. And the other thing, and the only caveat I'd make is, you know, somebody may say, oh, I really like this attorney, and they're a really good friend of yours. And then for some reason that attorney doesn't fit for you. That's okay. There's, you know, beyond, obviously you want ethical, you want someone who has a good reputation, you want someone that is going to listen to you, but not every professional, no matter whether it's an attorney, a financial advisor, a coach, whatever it might be, is going to be a fit. So there's a variety of things. And I would say, you know, I'm the queen of wanting to check something off a list. So I get how you want to be like, done. But I would fight that urge and take some time, because it is a big decision. And I also think once you make the right decision for you and your family, it can feel so good. A lot of those fears go away.
Mm-hmm. One other quick thing to add to that is that you need to understand what the lawyer is saying. It shouldn't be, can you hear me? Am I staying on this table?
Yeah.
It's Jeanne, when she explains it, you can understand it.
Yep.
And sometimes I'll read documents. My job here is to read every trust that comes in and summarize it down to a page. And some of them I mean, it's incomprehensible. And incomprehensible is not the lawyer's job. So if you get a document from the lawyer as a draft and it's gobbledygook, that's probably not a good fit for you. You know, the better the lawyer, the simpler they can make it to understand, because it's complicated stuff. And it shouldn't be about the lawyer being so important that you have to call them every day to understand what line 1 said. You should be able to sit down with a lawyer and have them explain it in the way that you can, when you walk out your door. You might have questions, but you basically understand what you're doing. You agree with that?
I also would say that it is a place where you just don't want to shop according to price. Many years ago, I've had a couple of different lawyers that I've worked with in different capacities. And many years ago, my husband and I did our first will, newly married. You know, it was like the bargain paralegal down the street. And we saved money, but we threw that money away because it was worthless when we got to somebody else. I'm sure her heart was in the right place. She just didn't have the technical skills. So it's really also thinking about, this is an investment in my life. And being able to, you know, compensate somebody for that expertise, I think is really key.
Jeanne, can you speak to that? Someone's had a question about what are typical fees, and are they based on hours? Is it a set fee? How do you know if someone's charging you too much, or if you're not getting a good plan because you're paying too little?
So there are some lawyers who like to do estate plans for a fixed fee, and I don't get how that works. And their fees are usually a lot higher than mine. I think that most people who just do estate planning charge by the hour, and how much it's going to cost you to do an estate plan depends on how complex your assets are. So if you have tax issues, and how complex your dispositive provisions are, and how much help you need. I have some clients who want me to hold their hand while they go to the bank to, you know, put designations on it and have 10 questions a day. that costs more. And then I have other clients who are super efficient and highly competent, and they take care of everything themselves and just say, did I do it right? And that, you know, and I let them know. So it really depends. The one thing that always concerns me about lawyers who charge a flat fee for estate plans is that they don't consider you a long-term client. So you're one and done, you're out the door. So for our firm and even for solo practitioners, you want a client from a business perspective who's your client for forever, because if you have a relationship with your client, not only, I mean, we're in business, you make more money, but it's a more satisfying relationship and it's more efficient and it works better. So for me, I like to see that a lawyer charges by the hour, but that mindset is that we're going to have this relationship now until you die. And I'm going to help you with everything. And if I can't do it, I'll find somebody who can help you with it.
Terrific. Thank you. So I want to jump back just a minute for 1 second. Someone asked a really interesting question, and I'm going to address it to you, Sue, about what the typical, if there is such a thing, how long probate should take if someone does end up there.
It really does depend on what the assets are. If there's real estate to be sold, or property to be, you know, real property to be divided up, as we talked about before, that can be very difficult. If you're waiting for property to sell and you can't close the estate, it's going to take as long as it takes to sell the property. People who are efficient and organized can really, there's a several month period of time in which you need to publish for creditors, and creditors can come forward and file claims. But you should be in and out in 6 months unless it's really complicated.
Okay, 6 months. Okay, now we're going to shift the conversation a little away from the oh, go ahead, Jeanne. Sorry.
That's from Sue's perspective as like the but one really important thing to know about probate is that you can't leave there until you get estate tax clearance. And tax clearance, if you have to file something with the federal government, which more people do than you would suspect, right now can take over 2 years. So you can be in probate for a very, very long time, even if the probate judge isn't aware that you're there, because there's no active filings in your case. But you as a private individual and all your family members can just be sitting there waiting for years.
Yeah, well, that is true, because they could have done all the probate piece that I would deal with as the court, and then you're waiting for your tax clearance. That's true.
I think this is a beautiful segue to my next question, which is, how do you maximize your gifts to heirs, organizations, friends, and minimize what goes to the government?
You give it all to the Vermont Land Trust? Is that the answer? I'm gonna let's talk about that a little too.
Very streamlined and easy when that works.
Yeah, but I will say that estate tax right now is a really crazy arena. Right now, the estate tax exemptions, which are the amount that you can pass to your heirs free from estate tax, are extremely high. The federal exemption is $11.4 million a person, and the Vermont one will be $5 million a person on January 1st. But unfortunately, as everybody knows right now, we're on the precipice of this terrible global economic disaster. And so I think everyone's anticipating that that's going to change, and that all the exemptions will come way, way down, because the only place to get money is, you know, there's just not that many places. So you can give your stuff to 3 people. You can think of passing assets as a pie, and there's 3 pieces in the pie. There's taxes, there's charity, and there's your beneficiaries. And the only dial you can change on that pie is you will give less to the government in taxes if you give more to charity. So you can trust the government to do things to take care of our country, or you can trust charities to do it. But the same amount will go either to charity or the government. You can't change how much that is. There are sophisticated things you can do to change it a little bit, but that's basically it. So that's a primer on that issue. I think Sue and Kathleen will want to add to that.
Go
No,
ahead, Kathleen.
That's good.
Well, there's an addition. You know, one of the things I would encourage people to do, I also work a lot with the financial services industry. And if you have a credible, holistic financial advisor, they can also help you think about these decisions in connection with your estate attorney regarding your business and your individual life, which I think is important. And again, I do think that, and, you know, I just recently learned about the Vermont land trust, but I think you can look for places that you want your money to have an impact, and that can really be an important piece and be less of, in layman's terms, a downer to think about yourself dying and to think about what do I want to use my money for? What impact do I want to have when I am no longer here? So I do think charitable giving is something that's really, really important, not only for tax considerations in concert with your estate attorney and your financial advisor if you have one, but also women, and I don't have the stat off the top of my head, you might, Christa, but women by and large really do want to have an impact with their wealth and when they're accumulating wealth. And so this may or may not fit you because all of us may share a gender or a gender identity. It doesn't necessarily mean we all think the same way. But often we do want to have an impact in our local communities. And so really thinking about locally, what is the way in which you can have an impact and how can you build that into your trust or your plan for giving currently?
And maybe just to clarify, it may be too simple a comment, but oftentimes people are looking at that estate tax exemption. And as Jeanne said, it's probably going to drop way down. But right now, people will be looking and saying, well, I'm not going to pay an estate tax in Vermont on the first 5 million beginning next year, but I have more than that. So I will give away to charity the amount above which I would be taxed on. That's a really simplistic way of looking at it, but that's a consideration.
I think I have one last poll question, and I'm going to launch it right now. It's asking if you'll be including a charitable organization in your will.
Oh.
And we have 34 participants still on, and I'm curious to see if people are already thinking along those lines.
I wish as a panelist I could vote. I've held that in for almost, 75 minutes now, but
Yeah.
I'm going to share.
Okay, it looks like 86% of the people in attendance will be including a charitable organization in their will, and that's fantastic. I think that's one of the primary ways, as we've already mentioned, with cuts happening through the federal government and on municipal and state levels, the social services, land conservation, things that we see happening around the state that are imperative to keep our society, community, culture, arts, all those things going, still need to happen, and being funded independently through donors is one of the best ways to make that happen. So there are I want to toss out a few ways that I've seen people include the land trust in their own planning. And one of the easiest ways is through a beneficiary designation. That's simply naming the land trust as the recipient on some of the documents that we've talked about previously. There are also possibilities of gifting land. We find that because we are a land trust, we're often the first person that's called when somebody is considering making a gift like that. Many people may not know that you're able to make that irrevocable gift and still live on the property during your lifetime. That's a possibility that could be discussed. If you had more interest in that, you can just be in touch with me. Another interesting gift that a lot of people are not aware of is called a charitable gift annuity. So if you have the intention of making a gift to an organization, but you don't necessarily want to lose the stream of income or lose your income level now, you can make an irrevocable gift to the organization, and then it creates a line of income for you for the rest of your life. That's something I can talk to you about separately after the call if you're interested, but those are some options that we currently offer and have found to be very rewarding to the donors as well as beneficial to the Vermont Land Trust. One of the last things, these are some new developments that have happened tax-wise that I'm wondering if you all would like to add anything about both the Secure Act and the CARES Act and how those things are impacting decisions people are making now. Jeanne, do you want to start that off?
So I guess my short answer is no. I received this in the mail.
Oh.
I would say that for me, because I've been so busy with estate planning for clients, that I made the deliberate choice to make other people in my office aware of what was going on with the PPP and changes to charitable deductions, et cetera. There were, under the Secure Act, some interesting changes to IRAs, which I don't think are relevant right now, though I would like to point out that if people have retirement accounts and regular assets and they want to pass assets to charity and to heirs, you should always pass your retirement assets to charity, because a charity doesn't pay income tax on a retirement account, whereas an individual heir will. That's just sort of a basic 101. But I think that Kathleen and probably you, Christa, are best to talk about the changes under the recent coronavirus tax relief.
Kathleen?
I mean, I just know about the PPP loans and about, because of my, I'm an entrepreneur in a business. I don't know about the tax implications. I do know if you get a PPP loan, which is for payroll and some other very limited expenses, if you were able to file and get some of that money, that if you can prove that 75% of it was given to payroll and used for payroll and your company stays open, that becomes a forgivable loan. But beyond that, the business aspects, I'm not that familiar with it.
It is complicated stuff. We've had a bunch of trainings on it, and we have a couple of IRA experts that really know the rules. And for people who have IRAs that are taking required minimum distributions, you don't have to take them this year. That's kind of a big deal for some people.
Right.
They also changed the rules for how IRAs pay out after the donor dies, whether you can extend the payment period over the lifetime of the beneficiary, which you could, and now they've shortened it to 10 years, which is a pretty radical change and is going to affect estate planning documents. We are in fact ourselves kind of scurrying to try to come up with language to come around that, because that does make a big difference for people. You don't want to jump into a pool of money when in just a few years when they're still really young. You want to be able to stretch it out. But those are things that you really would have to talk with your lawyer about in more detail.
A couple of the things that I was thinking of specifically was that the age for required minimum distributions from IRAs has now been raised to 72 from 70 and a half. So people get a little extra time before they have to draw money out. The ability still to make qualified charitable distributions from your IRA exists. So if you're not wanting to add money to your taxable income, you can make a gift of up to $100,000 from an IRA directly to a charitable organization, and that will not be added to your taxable income. Additionally, this year, previously, because of the higher standard deduction, many people were not itemizing for taxation purposes, so they weren't receiving a benefit by making charitable contributions. So a rule has been enacted to allow every person, even those who don't deduct, a $300 charitable deduction credit. So if you give $300 away, that is an automatic credit to your tax liability. And then lastly, previously, if you made a gift of cash to an organization, you could deduct up to 60% of your adjusted gross income if charitable gifts were made in cash. And the rule has been now changed to 100% if the gifts are made in cash. So you could theoretically if you donated in cash 100% of what your adjusted gross income is, you would have a zero federal tax liability. Not saying that's the best idea or that you should do it, but it's out there. So I think this is a good place to kind of wrap things in and throw out there if anyone has any final questions they'd like us to talk about. It's 11:25. We have about 5 more minutes. I do see one question about long-term care. What about long-term care insurance for a widow with some assets but no mortgage? Do any of you feel confident about answering a question about that?
Well, I don't know how you feel about it, Jeanne. Long-term care is good. It's also expensive. And we also spend quite a bit of time advocating for folks who have it, trying to get the company to pay once the person wants to start receiving it. So I wouldn't say that it's a bad thing, but I think it's something to be carefully investigated, because we've really had to really go to bat for, by the time people are looking for this, they're old and they're frail and they can't help themselves. And so if we weren't there, or someone who was their advocate, they would have paid all this money and not gotten it. What's your thought, Jeanne, on that?
So I think that the most important thing in that scenario is to, I don't know how old the person is or what their net worth is, but to sit down with your financial advisor and figure out what your needs are going to be for the rest of your life. Somebody like Kathleen or Trust Company of Vermont could sit down and say, here's your estimated story arc for how long your assets will last and your estimated costs. And then you can understand what your budget is. This goes back to the very beginning where it said, put all your assets down. Long-term insurance, if you purchase it later in life, is not really, it's really expensive and there's no guarantee of payment. I think there are some good products out there, but you have to invest when you're young and as part of a comprehensive financial plan, not as a Hail Mary at the end of the day. So not a glamorous or exciting answer, but yeah, sit down with your financial advisor. Even if you don't want to engage a fancy financial advisor, go talk to somebody at Community Bank or People's. I mean, even they have wealth managers who can sit down and say, like, here's your story arc estimate. Those are sort of fixed concepts in the finance world.
I think the other thing, and I actually just want to add very quickly, because I know we're ending time. My husband and I just went through this process, which is far from glamorous or fun with our financial advisors. And, my sense of it is that there are so many different products, and long-term care has changed very much in the last decade. So certainly find somebody who's credible in whether they're an advisor or a consultant, because I think there's a lot of products that you will spend a lot of money and maybe not get your return on investment what you're looking for. But there are also some products, so many so that we had a huge Excel spreadsheet and it was overwhelming, even though we had people with us. Mm-hmm. So it was a pretty long process of deciding what to do. And I think everybody's situation is individual. It also depends on your level of wealth. And, there's so many different factors. But I wouldn't say it's necessarily, I don't believe it's not something to investigate. I think the sooner you can investigate it and rule it in or rule it out, it will be a better piece of your comprehensive puzzle. And because I tend to be the person on the panel that is talking about money conversations, it's also another way to engage in a conversation, not just about money, but also about long-term health and health directives and what your wishes are as you age. So it can serve that purpose even if you decide not to invest in it.
Christa, we have somebody who's raised her hand, and I think she deserves to be heard because she's the only one that wanted to ask a question in real time. So here she is. Kyla, go ahead. Oops.
She's muted.
I know Kyla.
Well.
Oh, hi. My apologies.
I only took 3 clicks, but you're unmuted now.
Oh, perfect. Can you hear me?
Yes.
Okay, sorry about that. Actually, my dog hit the button. But perfect. I actually am a financial advisor. And so we actually, with our clients, we deal with this question quite frequently. And as it was mentioned, you know, long-term care, it's kind of one of those things that can be more expensive as you get older. And it's different for every client, but there are so many products out there. And kind of the biggest thing with a financial plan is just putting in control and flexibility and the ability to pivot at any time. Because we don't have that crystal ball. And we want to make sure everything is taken care of. So I would suggest anyone to kind of reach out and have that conversation, because you don't know what you don't know until you kind of have an educational conversation. Usually you can find something that fits for you.
Terrific. Thank you. That's great advice. I appreciate that. And thanks for speaking up. Our sole hand raiser.
An empowered young woman.
Yes,
I love that.
exactly.
Love that.
All right. Well, we have come to 11:30, our witching hour of closing this seminar down. I really sincerely appreciate everyone who attended our webinar today. I am so grateful to our expert panelists for giving us their time. They're going to get some magical little gifts on their doorstep later this week in appreciation for your time with us. And if anybody has residual questions, you're welcome to direct them to me, or the emails for all the panelists are in their bios, which are listed on a resource sidebar on our website on the events page. So you're welcome to hit that up and reach out. I'm assuming you guys are okay for people to reach out to you directly. Okay. So if there aren't any other questions, I'll just thank you all very much for joining us, and I hope you all have a lovely rest of your day.
Thank you, Christa. Thank you for putting it together.
Thanks, everybody.
Nice to meet you, everybody. See you.
Okay, bye-bye.
Bye.